Okay, Chapter 9 is basic contract law. So, an introduction to contracts. Now, before we go into this, I want to tell you, try to differentiate for you something that I hope will be helpful. I see you got the bad printed version. I'll give you the one that doesn't have those bubbles all over it. Hopefully this will help you. When we see a contract question on the exam, there's actually two different types of contract questions. There's what I call generic contract law questions, Chapter 9 questions. And then there's going to be Chapter 10 questions. The Chapter 10 questions are about a specific contract. In fact, the specific one that I'm talking about is the one that the North Carolina Association of Realtors, remember we went through the North Carolina Association of Realtors exclusive right to sell listing agreement? You guys remember that? We talked about how they publish forms for their members to use. Do you think they probably have a sales contract that they publish for their members to use as well? They do. And we're going to go through that contract pretty detailed and talk about what's in that contract. But early on in the process, you need to condition yourself to know, are we talking about generic contract law or are we talking about that specific contract? Does that make sense for everybody? Everything in this chapter is generic contract law. We won't talk about the specifics of that contract. For your reference, when you're on the exam, you got to know how to shift gears mentally. They will tell you. If it says in the Association of Realtors standard offer to purchase and contract, that's a question about the contract, that one, not contracts in general. Here's another way to know. If you're in the national section of the exam, it's a generic contract question. It's a contract law question. If you're in the state-specific section of the exam, it's probably what? It's probably specific to that North Carolina Association of Realtors contract. Does that make sense for everybody? So just looking to see what section of the exam, or reminding yourself, okay, I'm in the national section, so this is a general contract law question. And here's why I say that. We're going to talk about a lot of topics like earnest money. We're going to talk about contingencies. We're going to talk about things that are one specific way in that contract, in that offer to purchase and contract. But that doesn't mean they're always that way. They might work differently in other contracts. Are you following me on that? So I'll give you an idea of what I mean. The word contingency. Before we even get into this chapter, let's talk about the word contingency, because that's a word that comes up a lot in these two chapters. What is a contingency? Does anybody have in your mind what a contingency might be? Stipulation is a good word to put on it. A stipulation, a condition is a good word to put on it.
One thing has to happen or another.
Perfect. JJ said one thing has to happen, or I could say it the other way. This thing can't happen in order for this, that. It's an if-then statement, right? If this happens, then I don't have to do this. In a contract, a contingency is a get-out-of-jail-free card. A contingency gives you the right as a buyer to do what? Back out. And not just back out, but back out and get what? All your money back. Any deposits you may have paid, any money you have may have paid in the transaction. A contingency gives you the right to get out and get your money back. So contracts might have many contingencies built into them, particularly to protect the buyer in a transaction. Yes, ma'am. Finance contingency, absolutely. So a finance contingency would sound like this. I have to get a loan in order to purchase your house. If I don't qualify for the loan, or if for some reason I can't get the loan, then what? Then I get my money back and you let me out of this contract. That's what a finance contingency would do. So who does that help in the transaction? The buyer. Who does that hurt in the transaction? The seller. So buyers generally love contingencies and sellers generally what? Hate them. Don't want them. Because contingencies are generally there to protect the buyer. And anytime you protect the buyer, of course, you're doing it at the expense of who? The seller. Does that make sense for you guys? So that's the generic contract law idea. One of the things you're going to learn when we get to the contract, the North Carolina Association of Realtors contract, and why do you think we teach you that one, by the way? It's not because the Real Estate Commission says you use this one, because the Real Estate Commission doesn't say use that one. Why do we bother to teach you just that one? It's the most common. It's by far the most commonly used one in North Carolina. That contract has 0 contingencies in it. None. So when you're answering a question about that contract, you have to think there are no contingencies. So if you see a question that deals with contingencies, is it a question about that contract or is it a generic contract law question? It's a generic contract law question. You see where I'm getting at? So you really have to pay attention to the details in these 2 chapters to know what you're being asked about. Okay, is everybody good? All right. So let's dive into this. What is a contract? I'll tell you what it's not. It's not what most people would tell you it is. It's a bad way of thinking about it. See, I can tell you what word in that definition people focus on. People focus on this word, promise. If you ask somebody a one-word definition of a contract, the word they'll throw out at you almost, and even I'm talking about people who teach contract law for a living. The word they'll throw at you is promise. That's a load of bull. Because you can make a promise all day long without it being a contract. You can promise somebody you will do something, and that doesn't cost you a dime. Nor can anybody hold you to that promise. Do people break promises? All the time. So the important word in this definition, it says a contract is a legally enforceable promise between legally competent parties. The important word is not promise, folks. The important word is enforceable. See, we don't care that these 2 people have made a promise to each other. That's nobody's business but theirs. What we care is that they went an extra step and made that promise what? Enforceable, which means a court of law would intervene if there was a dispute between the 2 parties. Because that's the other thing about contracts. 99% of the time, contracts don't matter at all. Because 99% of the time in a real estate setting, for example, people do what they promised they would do. A seller promises to sell their house for $250,000. The buyer promises to pay $250,000. And guess what? Lo and behold, the closing date shows up, and here's a buyer with $250,000, and here's a seller with a deed. Have they done what they promised they were going to do? Yes. And guess what? Nobody in the room is going to go, whoa, 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 wait a minute, let's look at the contract and make for sure that everybody's doing what they promised to do. If somebody stops the closing to do that, you have my permission to knock them out at the closing table. Because if you got a buyer with money and you got a seller with a deed, you better do what? Close. Damn the contract. Who cares what it says at that point? Because clearly everybody's ready to do what? Move forward with their lives. You see what I mean? So the contract doesn't matter when the people show up and they're doing a thing and everybody's happy. When does a contract matter? When they don't. When they don't show up. When they don't do what the other side feels that they promised they would do. That's when a contract matters, because at that point in time you start looking for relief. When somebody doesn't do what they promised they do, you start looking for some relief. And where do you find that relief contractually? In a court of law. That word, enforceability. So the whole magic here, the thing we're paying attention to is not the promise. We're paying attention to the enforceability part. Would a court of law force these people to do what they promised to do? Would it hold them responsible for those promises? Are you following me on that? So I'll give you another real world example which I think works real well. I keep doing this, y'all gonna think I'm a cynic about marriage, but I'm not. It's just an easy target. If you're dating someone, if you have a significant other, Can you make a promise to them of fidelity? You're going to be loyal to them. You're not going to cheat on them. Can you make that promise to them? Absolutely. Is that a legally enforceable promise, though? It absolutely is not. But if you marry that person, if you create a contract between you and that person, is that promise of fidelity now legally enforceable? I.e., if you break that promise, can you be held legally responsible for breaking that promise? Can you be sued as a result of breaking that promise? That's what a lawsuit for divorce is called. Because you have violated a legally enforced, and not only can you be sued for it, can you have to pay damages for it? Absolutely you can. Ask our friend over in Morrisville. He wasn't even part of the contract, and he's got to pay $8 million. Y'all see that last week? Lawsuit for alienation of affection.
What is it?
That's called interfering with a contract. See, not only do contracts matter between the two parties, but they matter to the rest of the world, because a contract, because it's legally enforceable, the law says that not only can the two parties not break that promise, but a third party can't jump in the middle of them and cause that promise to be broken. And so guess what? Homeboy jumped in the middle of a legally enforceable promise. I hope it was fun. $8.8 million this ex-husband was awarded for alienation of affection in Morrisville just last week. It blew my mind. I was like, whoa, goodness. Yes, ma'am, Marla.
Because I had heard that in North Carolina it was like $250,000 the person could be fined for messing up somebody's.
Apparently it's 8.8 million. I don't know what that works. I don't know what that works out to hourly, but it's a lot. I know that. It's a lot. It's a lot. But do you understand the difference there? The two people, they made a promise to each other that wasn't enforceable. It was the marriage, that contract, that made it enforceable. And that's where all the penalties come. Does that make sense for everybody? So this whole chapter is not about promises. It's about, are the promises enforceable? Would a court of law honor these promises? Do you get the difference there? Yes, sir, JJ.
Does it have to explicitly indicate certain terms, or is there a gray area that...
Well, the whole idea of contracts is to eliminate the gray area. That's the purpose of contract law. So what we're going to talk about for much of this chapter, if not all of this chapter, is what are the specific things that have to be in place in order for it to be enforceable. Because there are certain things where a court of law says, no. You might have had a promise with each other, but we can't do anything about it. We can't touch it because you didn't follow the rules. You didn't create an enforceable agreement. A court of law is not going to enforce just any old agreement. There are rules to creating an enforceable agreement, and that right there, see, that's a great question, because that's what this chapter is all about. This chapter is all about knowing what the rules are so that you never create an agreement that's unenforceable. See, that's an ugly word, unenforceable. You don't want to hear that about a contract that you have a part in. The contract is unenforceable. You said it right, Ken, you're not going to get what? You're not going to get paid because the two parties don't have any responsibility to each other, because a court of law is essentially saying, I don't care what you think you promised to do, those promises are not strong enough to be legally enforceable, so you're on your own. That's what unenforceable means. That does not sound good to me. I don't know about y'all. See, I want to hear the word enforceable when I'm talking about a contract that I'm involved in. Is everybody with me on that? So that's where we're going. We're going to talk about enforceability here. First requirement, what do we need to have? The first requirement is that the contract be voluntary. In North Carolina, like in every other state, you can't be coerced or forced into an agreement and have that agreement be legally enforceable. If a court of law finds out that you were somehow forced into that agreement, what do you think they're going to do with the agreement? They're going to throw it out. They're going to throw it out and they're going to say, you don't have to follow this agreement. So if JJ signed an offer to purchase and contract at knife point because his wife said, if you don't sign this, I'm going to cut you. Well, yeah, it might be signed and it might look like a contract, but if JJ were to go to court, could he probably get out of that responsibility? Absolutely. Because he's going to tell the judge, Your Honor, I was at knife point. I signed in fear of my life. That's not voluntary. Does that make sense for everybody? Okay. So the first requirement is that it be voluntary. The second requirement, and we're going to talk a lot more in depth about this in chapter 10 as well, is that we have a meeting of the minds. We need to show a clear agreement with the two parties. We also call this process the offer and acceptance process. Remember the O-R-E-E words? This is where we're going to use offer or and offer E a lot. The offer or is the person doing what? Are they making the offer or are they receiving the offer? They're giving the offer. They're making the offer. And the offeree is what? Receiving the offer. So if for example, Wendy is making an offer to purchase Patrice's house, who is the offeror? Wendy. And who is the offeree? Patrice. Now, Patrice doesn't like that offer. She doesn't like that number. So she crosses the purchase price out and she writes a new number in there and she signs by that new number. Now, that's called a counteroffer, right? Here's what it also did. It switches the roles. Now who's the offeror? Patrice. And who's the offeree? Wendy. So here's what you need to understand about this idea of a meeting of the minds. What we need to show is that the offeree agrees with what the offeror offered. It's always the offeree who's doing the agreement because they're always the one that's second in line. Does that make sense? We know the offeror agrees because they made the offer. What we have to show and prove is that the offeree agreed to those terms without making any changes. That's what we mean by a meeting of the minds. Is everybody okay on that? That is the meeting of the minds. So when we talk about contract acceptance later on, who does the accepting? Is it the offeror or the offeree? The offeree does the accepting, not the offeror. We also need legally competent parties. Unlike our friend here who's had a rough night. We need legally competent parties. North Carolina contract law says that if you are not legally competent, you can't be held responsible for what you do. And there are several examples of people who are not legally competent. Number one, people under the age of 18 are not legally competent. And in the case of males, people under the age of 35 are not legally competent. But 18 is the age of adulthood in North Carolina. I always tell this joke, but it's true. If you have like a 16 or 17-year-old home and they start arguing back and forth with you, all you got to do is pull this statute out, because the state of North Carolina has an interesting word that they describe people under the age of 18. They are infants. That is literally how they are described in North Carolina general statutes. If you're under the age of 18, you are an infant. You go straight from infancy to adulthood, which does sort of work for men, right? That's about the truth, right? You know. But 18 is the magic age for contractual purposes in North Carolina. So here's what we mean by that. Anybody under the age of 18, can they make a promise? Of course they can. Can they be held responsible for that promise? No, and there's the difference. So can a person who's under the age of 18 purchase a house? Yes, of course they can. Can they be held responsible if they sign a contract to purchase a house and then they change their mind? No, because that contract is not going to be enforceable against that minor. Does that make sense for you guys? That's what this chapter is all about. It's not about can they do something. Of course they can. It's a free country. It's about would a court make them do it. Are you with me on the distinction there? Other things that would make somebody mentally incompetent. Well, obviously if they've been declared mentally incompetent by a court of law, so if they've been appointed like a guardian or a ward, they're a ward of somebody, court has said they don't have the legal ability to make decisions for themselves. This most often happens with older people, parents, you know, that sort of thing, who get to a point where they can't really handle their own decision making, and so they might give somebody an unlimited power of attorney, or you know, that sort of thing. I'm sure most of us are familiar with that. Of course, a court could also come in and declare someone to be mentally incompetent. But look at this one. Intoxicated people. An intoxicated person is not a mentally competent person. So what that, I'm sorry?
I said, you can't tell them that.
You cannot tell them that, unfortunately. Good luck telling somebody under 18 they're not mentally competent either. You know, that's the whole idea of mentally competent. It's very hard to explain that to these people, right? Do you understand the words that are coming out of my mouth? Comes to mind a lot of times. But if they are intoxicated, they also can't be held responsible for what they are doing. So that's something you need to look out for on a test. If they say that somebody goes to a closing and they sign all the documents and they're clearly intoxicated, well, are those documents going to be enforceable documents? No, because at least one side was messed up, drunk, high, whatever it is, drunk and high. I don't know what they were. But I know they were intoxicated, and therefore they can't be held legally responsible for anything that they agreed to. Is everybody following me on that? Okay? So that's a big requirement. Another big requirement, and probably one you should star in your notes and come back to several times, because this is going to be one that confuses you on the exam. I know from experience with this one. Contracts in North Carolina, like most any other state, need something called legal consideration for them to be enforceable. Legal consideration. Now, most often consideration is money, but truthfully, consideration could be anything of value. Here's what we mean when we say a contract needs to have consideration in order for it to be enforceable. Both parties, because every contract's got two parties. That's another thing. You can't have a contract with yourself. Okay? Don't do that. You can do it. Because later on tonight, we're going to start talking about unilateral contracts. And somebody's going to go, oh, unilateral contract, that's got one party. And I'm going to look at you like, moron, you can't have, I'm not going to say moron, but I'm going to think it in my brain, right? You can't have a contract with yourself. Contracts always have what? Two parties. So consideration means both parties have promised to exchange something of value. So think about a sales contract on a home. What has the seller promised to bring of value to the transaction? The property. What has the buyer promised to bring of value? The money. Is that legal consideration? Have both parties promised to exchange something of value? Now here, let me point this out to you. Notice I didn't say it is required that they have already exchanged something of value. It's not required that they've already done it. It's required that they have what? Promised to do it. Because here's what they're going to try to do on a test. Can I repeat it? Yes. You want to just run it back on the camera or no? So, it is not required that they've actually exchanged the thing of value. It is required that they have promised to exchange something of value. So here, let me point out the difference to you. On a test, they might say that you've got a buyer and a seller who've agreed on a sales price of $250,000 to purchase a home. They've also agreed on a $1,000 earnest money deposit. The buyer has failed to deliver the earnest money deposit. And then they want to know if we have a binding contract. And a lot of people would be tempted to say we don't, Because there's no consideration. Because there was earnest money, but it didn't get what? Paid. It's not necessary that it gets paid. What the consideration is the promise of the exchange of something of value. So as long as both sides have promised to bring something of value, the contract, the promises are legally enforceable. Does that make sense? Now let me give you an example of somebody not promising something of value. Teresa has agreed she is going to give Alice her house. They get an attorney to draft a document, sign it, write it down, take it to the courthouse and record it. Man, we just going to go the whole 9 yards. Teresa is going to give Alice her house. Is that a legally enforceable promise between those two? No, and no amount of writing it down, getting an attorney to draft it, recording it at the courthouse can make it legally enforceable, because both sides have not promised to exchange what? Something of value. Teresa has clearly promised to exchange something of value, the property. But what has Alice promised to do? Nothing. So Alice is going to be real nice, and she's going to go, oh, no, I insist. I must give you $1 for it. I at least have to buy you a cup of coffee if you're going to give me your house. Because if she promises to give her $1 for the property, does all of a sudden that promise become legally enforceable? Yes, because there's a promise on both sides to exchange something of value. Does that make sense for everybody? That's what consideration is. It's the promise that at some point in the future, both parties are going to bring something of value to the transaction. Okay? And you got to have it. The other way people always say this is you can't have a contract for no money. Does that make sense now when I say that? Because a contract for $0 is not a contract at all. Because at least one side's not bringing anything of value to the table. Okay? And this one. We would think this one would be obvious. For some reason people forget this all the time. Folks, it's not a contract. It's not enforceable if the thing you're asking about is illegal in the first place. If the thing, we said, a contract is just a legally enforceable set of what? Promises. If the promise itself is illegal, then of course the promise can't be legally enforceable. Is a drug deal a promise? Of course it is. You got a buyer, you got a seller. They have an expectation that one will deliver a product and the other will deliver some money. I've heard. Clarify. You don't have to have real world experience to teach something. Come on now. But you see what I mean, though? That's an extreme example, but is that a promise? Is it a legally enforceable promise?
It depends on which state you're in.
In North Carolina, that's a good answer, actually, right? In North Carolina, it is not a legally enforceable promise. Does that make sense? Because you can't. Imagine how silly you would look going to court. Your Honor, he promised he would sell me an ounce for $400. And I gave the man $400 and I waited and it was only half an ounce. What is the judge going to do with you? I can tell you what they're not going to do. They're not going to enforce that agreement. You can have it in writing. You can do whatever you want to do. It's not enforceable. Because the actual promise is what? Illegal. The underlying promise is wrong. I want you to write a word on this slide. We're going to come back to it later and we're going to talk about it at that point in time. But I want you to write one word on this slide. Any contract where the thing that's being promised is illegal is called a void contract. And that's the only thing you better ever call void in front of me. Don't you say somebody's walking away so the contract's void. No. Because a void contract has a very, and that you're going to miss it on the test. That's why I get frustrated with it. I'm not frustrated with you. I'm frustrated with how easily you get sucked into that on a test. Void doesn't mean gone. Void means never was. Legally, void means this never was a contract because the promise, the thing that you're asking us to enforce is what? Illegal. That's what void means. So don't ever use void for any other circumstance. If you feel it's about to come out of your mouth and you're not talking about an illegal act, stop and come up with a different word. Because I can guarantee you void's only going to apply in this class on this test to contracts that are for illegal acts. Is everybody okay with that? Good. And it doesn't have to be so blatantly illegal. I mean, there are things that people do. So I'll give you an example I'll give you an example of a void contract from the planning and zoning chapter, from chapter 6, land use controls. Let's say this property, right here, this building, is located in an area that is zoned strictly residential. I go check the zoning. It's zoned strictly residential. Now, is this a residential use? Now, that doesn't mean we're automatically in trouble, because now what do I have to check on? I have to check on when what happened. When did the zoning come into effect and when did the use start? Because if the use started before the zoning, it's what kind of a use? Grandfather would call that a legal, non-conforming use. If the use started after the zoning, it's an illegal use. Does that make sense? So now I have leased this space from Hobbs Properties. And in my lease it specifies that I am leasing it for the purpose of operating a real estate school, an adult educational program real estate school, and associated activities. That's what the contract says. That's the promise that I've made to Hobbs Properties, and that's the promise they've made to me, that the space can be used for that purpose. Does that make sense for everybody? So now, I've got this lease. I go check. I go and I look at the zoning, and it says strictly residential. And then I go and I look at, well, the building was built in 1982, and the zoning went into effect in 1978. Uh-oh. We got a problem, right? What kind of use do we have here? An illegal use. What does that do to that lease? It makes it what? Void. Because the promise, the thing that has been promised is what? Illegal. That is a void agreement. That is a perfect example of a void agreement in a real estate transaction. Because the thing that was promised is illegal. That property cannot be legally rented for that purpose. Everybody with me on that? Okay? That's a void agreement. So it means it would have no legal weight whatsoever. It's not worth the paper it's written on. Okay? Contracts can either be express or implied. We talked about this in chapter 8 as well, or chapter 7. Yeah, chapter 8. We talked about agency agreements. We said agency agreements could be express or they could be implied. What's the big difference between express and implied? What's an express agreement? Well, written is an example of an express, but we could have an oral express agreement. What's the big difference? If it's express, we've done what? We've specifically said, I don't know who said that, I think it may have been I. We have specifically stated the terms of the agreement. Even if it's oral, we've made it clear this is our arrangement. Does that make sense for everybody? Could we have an oral lease, for example?
Yes.
Absolutely. If the landlord discusses how much they expect the tenant to pay in rent, and the tenant understands that, that's an express oral lease. And here's the thing. Oral contracts are enforceable in many cases, not all. And we're going to talk about the cases where it's not enforceable to have an oral contract, but some oral contracts are enforceable. Heck, you deal with them all the time. How many of you go out to eat every once in a while? I don't mean McDonald's type go out to eat. I mean like sit down at a restaurant, order from a server. Do they express the terms of that contract you're creating with the restaurant when you order? Yes. They do?
They show you the menu, they ask.
I've been to some, they don't even give me a menu. I've been to some, they don't even have prices on the menu. And they certainly don't explain to me that I'm additionally going to have to pay taxes and what? Gratuities. It is understood that I will do what? Pay. That's an implied contract, folks. And so we have implied contracts all the time. We also have oral contracts all the time. What we're going to learn, like JJ's question earlier, is when does it have to be what? Written. There are certain times it has to be written. Here's what I'll tell you. Just because implied contracts exist doesn't mean you want them in real estate. In real estate, you don't ever want an implied contract. What kind of contracts do we want in real estate? We want express, and specifically we want what? Written express. Because we don't want to leave any doubt about what the intentions are. Is written always going to be king?
Yes.
No question. No question, because it's the most clear about what the parties actually intended. It doesn't leave it up for debate. Are you with me on that? And one important thing to remember, once it's in writing, it can't ever be changed orally. That's an important thing to remember. Whether we're talking about agency agreements or contracts, when you put it in writing, an oral discussion is worthless from that point forward. What do you have to do if you want to make changes to a written agreement? Put the changes in writing. Put the changes in writing. There was actually a case a couple months ago here in North Carolina in a sales contract. Now, I don't know why this real estate agent was recording his phone calls, but he was. He was recording his phone calls with the agent on the other side of the transaction. And they had discussed that the sellers were going to pay for a home warranty for the buyers. Now, the contract, they were already under contract, and the contract said no home warranty would be provided. There's a box right on there. It says the sellers will provide a home warranty, or the no home warranty will be provided. Well, the written contract said no home warranty will be provided. Buyers come in, they do their inspection, they find a couple issues, they have this negotiation about repairs. One of the things they negotiated was that the seller would pay for a home warranty for the buyer. But the buyer's agent never bothered to send over an amendment or change to the contract or put that in writing in any way. So they get to closing, guess what? No warranty. And the buyer's agent has a fit. They told me this, they told me that, which was all true. They did tell him that. And would you believe these buyers actually ended up suing the sellers over this home warranty here in Wake County? Over a $500 home warranty. They sued them. And they got to court. And this agent thought he was just, big as day. He's going to walk in there with his, I got the tapes, man. Well, I don't know if he thought this was Watergate or what. I can't imagine what the judge saw. And here's this guy comes in with tapes of his phone conversation. Tapes dates me, by the way. It wasn't on tapes. I'm sure it was digitally recorded somewhere, right? Those of you, some of you all are like, what's a tape? I feel sorry for you. You never had to hand wind one, right, to catch it back up? With a pencil?
Yeah, that ribbon.
Sit there, exactly. Exactly. Or try to get one out without breaking it when your car ate it, right? You ever pull one of those out and here the whole thing comes and now you got to do surgery on the car, try to get it out. and try to smooth it out, get them wrinkles out of it. See, y'all just don't even know the struggle was real for us, man. We had to work hard just to listen to some music. And you always want to hear that one song in the middle of a 3-hour tape, right? Fast, no, that's too far, go back, right? Y'all remember how fancy it was when you got the car that had the seek feature on it that would stop right where there was a blank space between the songs, I'm telling you, it was hard work back then, right? So here goes this agent. He comes into court. He goes into court and he plays this recording of him and the listing agent. The listing agent clearly says the sellers will provide it. But the judge looks at him and goes, what good does that do? The parole evidence rule, y'all remember we talking about that? It says the parole evidence rule says if you have a written agreement, the only changes you can make are what? In writing. So he has all the proof in the world, but he didn't have the one thing he needs, which is written. And that's an important thing to remember about this business is once you've got it in writing, there is no going back. It has to stay in writing because the law, the court system is going to follow what's in writing from that point forward. They don't care about an oral conversation because they're not allowed to. It's not even about what the judge cares about. They're not allowed to, because the law makes it very clear that once it's in writing, the only thing they can follow is what's in writing. Yes, sir.
Just so I can be clear, the express oral, is it just strictly oral, or is it oral and written based on oral? I mean, it's just oral.
It's just oral. So like an oral buyer agency agreement. That's an express oral agreement.
So you get into he said, she said, so how could it ever be enforceable?
Well, that's, well, when you ever watch Judge Judy?
Yeah.
That's all about he said, she said, isn't it? So then it becomes about who does the judge believe.
Okay, all right.
And that's why we want to stay away from that if we possibly can, because that leaves it up in the air. What's much better? Put it in writing, and then it's clear what the parties intended. See the difference?
Yes.
Okay. Yes, ma'am, Michelle.
Did he go in the back of the book?
Did he go in the agent? I don't know. I don't even know if a complaint was filed with the Real Estate Commission on that. I'd have to check. I have no idea. That's an interesting question. Back of the book, she means, was he reprimanded by the Real Estate Commission? They send out a month, not monthly, quarterly newsletter. And the only way they know they can get us to read it is it's like the slammer for real estate agents, because at the back of it they have everybody's name who got in trouble over the last, and so the first thing you do is always start flipping through to see whose name you recognize in the disciplinary action section. You'd be shocked. You'd be shocked. Some of those big names you see on a lot of signs sometimes show up back there, get disciplined by the Real Estate Commission. It does happen. My name has been in the bulletin, but not in that section of it. My name has not been in the back. No. It has been in the bulletin, but not in that section. So it's in the other section where they're telling you how good, how wonderful you are. No, thankfully I've never been disciplined by the Real Estate Commission. Thankfully. And I'm glad of that. In fact, I've had one complaint against me in my entire licensed career as a real estate broker, and it was from a student, and the complaint consisted of the fact that my final exam was too hard. And I had to respond to that complaint because they by law, they have to send me the complaint, you know, and then the student was mad because I saw their name. I'm like, well, what do you think they were going to do? You know, they tell you who files the complaint. So, yeah. That's the one I've ever had. All right, here we go. Bilateral and unilateral. Now, don't be that guy. Don't be that person, right? How many parties does a unilateral contract have? I heard somebody say that ugly one. It's not. You can't have a contract with yourself. There's still two parties, right? A unilateral contract still has two parties. The difference is only one of them has promised to do anything. Only one of them is bound by the agreement. Two parties, one that's bound. So let me give you an example of a unilateral contract. Let's say that Marlo is a buyer's agent. I think she was a buyer's agent for Sheets one time before, right? Isn't that right? Okay, well she's a big time commercial real estate broker. And she has been hired by a small company based in Bentonville, Arkansas, named Blue Ribbon Properties, LLC. Now, you may be unfamiliar with Blue Ribbon Properties, LLC, and that's by design. What you might be more interested to know is their parent company, which is Walmart Stores, Inc. But Blue Ribbon Properties, LLC has hired Marlo as their exclusive buyer representative because they want to locate a new store in Holly Springs. Okay? Now, Marlo has isolated this search down to 3 pieces of property. All 3 are currently undeveloped. These are undeveloped pieces of land, and they all have enough land available. They're all in areas that are zoned for commercial use. Now, they may require some special use permits. They may require some additional zoning considerations, but she feels like all 3 of them would work. Is everybody with me on that? Now, Walmart can't just decide we're going to buy this piece of land and then we're going to make it work. Because they got to work through a whole bunch of permitting processes. They got to talk to the State Department of Transportation. They got to do feasibility studies. Because are they going to have to add probably a new intersection wherever they locate this store? Are they going to have to widen the street, maybe put some turn lanes in? All these things have to happen. Here's the problem that Marlowe runs into, though. Marlowe has identified these three pieces of land, and one is owned by Ivy, one is owned by Alice, and one is owned by JJ. You got your three owners here. Now the three owners have no idea who has interest in their property, which is exactly what Walmart would like. Because if you're Alice and you know that Walmart is interested in purchasing your property, what just happened to the value of said property? It goes up substantially. Now here's Marlowe's other problem. She doesn't know which one of these three is going to be the best fit. Because she's got to work through all these feasibility studies. She's got to talk to the planning and zoning department. She's got to talk to the Department of Transportation. She's got to do all this exploration. And man, is it going to be tough to keep it secret who she's buying for through all of that. In fact, it's going to be impossible. It's going to get out. It's going to get out. So, here's what Marlowe's going to do. She's going to approach each one of these landowners individually. And she's going to say to Alice, Alice, I have a client who's interested in purchasing your property. We'd like to offer you $300,000 for this property. And so let's say Alice is agreeable to that number. But here's what Marlowe said. But they're a little bit reluctant to commit because we need to do some studies on the property. So here's what we'll do. We'll cut you a check right now for $25,000. And in exchange for that $25,000, you'll give us 6 months to make up our mind. You'll agree you sell us the property for $300,000, but we got 6 months to decide if we actually want to move forward with it. If we decide we don't want to move forward, you keep the $25,000, you go about your merry way. If we decide we do want to move forward with it, you sell us the property for $300,000. Does that make sense for everybody? That is called an option contract. That's called an option contract. Now, is Marlowe done? No. What's she going to do? She's going to go to the other two. She's going to negotiate deals with the other two. She's going to negotiate with JJ to purchase his property for $400,000, and she's going to pay him a $25,000 option fee. She's going to negotiate with Ivy to buy her property for $250,000, and she's going to pay her a $25,000 option fee. Now, once she's got those three options locked down, what is she free to do? She can have a press conference and say Walmart is coming to Holly Springs. And it's going to be located on one of these three pieces of property. She don't have to hide a thing now, because guess what? None of these owners can do. They can't change their price. They can't back out, because the owners are bound. They're locked in. Is Walmart bound? No. How many of those parties, so the agreement between Alice and Walmart, how many parties do we have?
3.
No, Alice and Walmart. 2 parties. How many of them have promised to do something?
1.
Just one. Just the seller. The buyer hasn't promised to do a thing. Does that make sense for everybody? That is a unilateral contract. That is a unilateral contract. And that is used quite often in commercial real estate, because here's what's going to happen. Now Marlowe's going to go do all her feasibility studies with the Department of Transportation. She's going to work with planning and zoning. And so here's what she finds out. She finds out that JJ's property won't work at all. Because of environmental issues, there's a rare snail that lives on the property. And so therefore they can't get the necessary permits to build on this property. So, she probably did. She probably did. So, the JJ's property's out. So JJ's going to keep the $25,000, but is Walmart going to buy his property? No. Now, she finds out that to locate the property on the store on Ivy's property, she has to put in a 4-way stoplight interchange with turn lanes in all 4 directions. Now, who's going to have to pay for that? Is that going to be the Department of Transportation, or is that going to be Walmart that has to pay for that development? Walmart. And the Department of Transportation has estimated that cost at $325,000. So, in addition to buying the property from Ivy for $250,000, they're going to be into this thing for another $325,000 in development costs. And they have found that the Department of Transportation says that for Alice's lot, because it is further away from other traffic choke points, they only need to widen the road for a quarter of a mile on either side with a third lane in the middle. They just need a left turn lane in the middle. Estimated cost, $27,000. Which property are they going to buy? They're going to buy Alice's. Now, here's the thing. If you had done all of that research first, and Alice, because is Alice going to know you're doing this research on her property? Absolutely. And she got a buddy down there in the planning office, and they'd be like, listen, Alice, you need to hold out for more money, because that one property looking at some snails over there, they can't do that, and this other one's going to cost them a fortune to put the traffic lights in. If they hadn't already locked in that price, what would Alice be doing right now? It would be $500,000, because here's what she's going to say. Oh wait, you offered me how much? $300,000? I think $500,000. Because by the time you buy hers for $250,000 and you have to spend another $350,000 on a traffic light, you still got $50,000 more tied up in hers. And aren't you going to renegotiate it? Here's the thing, she can't. She can't, because she's been locked in by that option fee up front. Does that make sense for everybody? That is a unilateral contract. That's a unilateral contract. There's actually, I visited a property recently down in Central Florida that was developed, and I'm not a very good artist, so you have to bear with me on sort of my map of the state of Florida here, right? So you got, this is kind of like state of somewhat ish. You got Tallahassee over here, right? And here's Miami down here, and here's North Orlando, right? Okay, everybody clear on where we are? All right. Okay. Hush. I recently visited a property in Orlando, and I met a young lady, and she was talking about her family owned a significant amount of land in Central Florida that was purchased through option contracts actually before she was born. I don't know, she's probably 60 now, and she said before she was born, her father owned a tremendous amount of land in Central Florida, and it was purchased with an option contract. And what they actually did was they came in and they took an option on this big piece of property in Central Florida, and they didn't exercise that option for several years, and they came in and it was like the Reedy Creek Development Corporation, which nobody had ever heard of, and they actually purchased 3 pieces of land. They took out options on bunches of land, and they eventually purchased 3 pieces of land, one here, and then there was 2 smaller ones up to the north of them. And that's exactly what happened with that. All of Disney World is built on land that was purchased with option contracts. When Walt Disney decided to locate that property down there, he never went in as Disney, because even at that point in time, Disney was a famous name. I mean, Disneyland already existed in California. He had told people that he was looking at that place to build Disney World. What would have happened to the prices? Skyrocketed. So he went in as the Reedy Creek Development Corporation, and he bought option contracts on just thousands of acres of land. You know how much her father, what the option price was? Per acre?
Per acre. 10,000.
Probably like 500.
$3.50
Say what?
per acre.
Back then it was just all woods, right? It's one.
$3. I wanted to cry for her. I mean, you can't buy a hot dog in Disney World for $3.50. And they bought an acre of land for $3. And you know how much they make off of that acre now every day? That's legal. because they locked in. And see, once they had locked in all these options, what they did is they started working with the state of Florida, they started working with Orlando, they started working with all these government agencies and determining where the best location would be, and then they exercised the options on the ones they actually wanted to move forward with. And by that time, everybody knew who it was and wanted to raise their prices, but they what? They couldn't, because they had these long-term options locked in.
So they just happened with Amazon.
What happened with Amazon?
There's the option, and like you were giving the examples, and then they picked the one that was already more feasible for them to do the.
Oh, they probably will. Yeah,
So they learn.
well, that's the distribution center. That's not HQ2. That's the baby Amazon that Garner just got. That's 1,500 jobs. HQ2 would be 50,000 jobs.
Yeah, that's the headquarters.
Yeah. Yes, ma'am.
So apparently they still have option contracts today?
Of course. Absolutely, we still have option contracts. Use them all the time, particularly in commercial transactions. Oh, you understand the idea behind them, though? Yes, ma'am.
So, but more likely when they did that negotiation, probably the 350 was standard or.
That was a fair price for an acre of land. That's exactly right. It was swampland. And that's what she said. She said her dad was glad to find, he thought he had found the biggest fool in the world. She said that he came home and told his wife, I found the biggest dummy in the world. They want to buy 3,000 acres from us at $3.50 an acre. Do you know that's $100,000 for this swamp? And they were proud.
Yeah, but that's a total, so they want to buy so much.
Well, that's the thing. Hindsight's always 20/20, right?
Yeah.
And that's the power of the option contract, because what it allows you to do is essentially, the key here is that the terms are locked in advance, because that's what it does. It locks down, but it only locks down how many sides? One, which is what makes it unilateral. Is everybody okay with that? Compare that to the bilateral contract. If you don't know who this is, I'm sorry, you grew up at a terrible time. I actually think he's probably on the way to the theater. He looks real happy in this picture. Sorry, there's a terrible joke in there somewhere. If you can figure it out.
With his beard and everything.
But a bilateral, you missed it. You don't want to get it, trust me. Trust me, you don't.
I'll tell you what it's got.
You just now got it, and it's a delayed reaction for him and you, apparently. Oh, no, I'm kidding. I'm sorry, it was too easy. Sometimes y'all set me up with them, and I have to go for it, right? It's just not fair. My next goal in life is to be a comedian, you know. It's just like...
You missed your calling.
So with a bilateral contract, how many of the parties, we already know there's two parties, but how many of them have actually promised to do something? Both of them. Both of them have promised to do something in a bilateral contract, as opposed to just one. So, that's right, buy versus unit. And so a normal sales contract would be a bilateral contract, because the buyer has promised to purchase and the seller has promised to sell. So that would be, a lease is a bilateral contract. The landlord has promised to provide the property and the tenant has promised to pay what? Rent. So two promises, both sides promising, that's bilateral. All right. We also have these two words which people tend to confuse a lot. Executed versus executory. Executed versus executory. I always hesitate to use this analogy because it's kind of morbid, but it works. When somebody is walking death row, headed to the electric chair, they are executory. The documents have been signed, the promises have been made, but the deed has not been done. When the switch is thrown, they are what? Executed. Contracts work the exact same way. when a contract is signed and the promises have been made, but they have not yet been fulfilled, the contract is what? Executory. So anytime a contract is signed but not yet closed, it is executory. When it is closed, it is what? Executed. An executory contract is one that's sometime between contract acceptance and what? What would be the executory time frame? It's been accepted, but it hasn't been what?
Closed.
It hasn't been closed. The only thing that makes it executed is closing. Don't make that harder than it is. So if it's anywhere between signing and closing, it is what? Executory. If it's closed, it is executed. Are we good on the difference between those two? Good. Good. And then enforceability. And we're going to take a break here in just a second. We'll come back to this word. But this word is the magic word. Everything in this chapter centers on enforceability. We know we have promises, but are those promises strong enough that a court of law would do what? Would force you to follow through with them. The word force is in there. The court can force you to follow through, or force you to pay some type of damages if you don't follow through. Is that also something a court of law can do? See, you can't get damages unless you had what kind of a contract? An enforceable contract. Because if the contract's not enforceable, the judge is just going to say, get out of my face. Get out of my face. I can't do anything with this agreement. The word enforceable is the only word that matters about contracts. Get comfortable with it. Because everything we're going to talk about when we come back from our break deals with, is it enforceable? And if so, on how many of the parties? How many parties is the contract going to have? Two. So what's the maximum number it could be enforceable on? Two. What's the minimum number it could be enforceable on? 0. So we're going to talk about contracts that go all the way from both parties being bound to nobody being bound when we come back from the break. Okay? All right, so let's take the first break. It sounded like I was going to like a TV break, right? Like I feel like I'm setting you up for like Deal or No Deal or something, you know? Come back at 7:30.